Why is the anti-terror law feared? Is it needed to secure the country from terrorists? Will it suppress freedom of expression? President Rodrigo Duterte signed the anti-terrorism bill into law despite strong public opposition. The first thing we need to know is this: the new law broadly expands the definition of a terror act. The repealed law, the Human Security Act of 2007, has only one definition for terrorism. It's a common crime that creates a condition of widespread and extraordinary fear. Under Section 4 of the new law, terrorism has 6 definitions. They are common crimes that intimidate the general public or a segment thereof, create an atmosphere or spread a message of fear, provoke or influence the government or any of its international organizations by intimidation, seriously destabilize or destroy the fundamental political, economic, or social structures of the country, create a public emergency, or seriously undermine public safety.
Supposing today there's a rally in UP against the Anti-terrorism Act, assuming this is a law already, they could be arrested because they're endangering the lives of people, because that would spread the virus and that will spread fear. That would fall under the Anti-terrorism Act.
Anyone found guilty would face a sentence equivalent to life imprisonment. Those who conspire, recruit others, and participate in the planning, training, and facilitation of a terrorist attack would also face the same sentence. Those who threaten, propose, incite to commit terrorism, voluntarily and knowingly join any terrorist group, or are accessories who either profit from terrorist acts, conceal evidence, or assist in the escape of a terrorist would face a lesser jail time of 12 years. Inciting, planning, training, facilitating, threatening, and recruitment are added crimes to the anti-terror law. The Human Security Act punished conspiracy only. Following the request of security agencies, the new law extends the period of surveillance and detention without warrant. Suspected individuals could be spied on by the government by monitoring their calls and messages for 60 days upon the order of the Court of Appeals. It may be extended for another 30 days, with the person in question being informed after the fact. Under the Human Security Act, surveillance can be done for at most 30 days only. Detention without warrant would be extended from 3 days under the existing law to between 14 to 24 days under the new law. Arrests are made upon authorization of the Anti-Terror Council, an executive body doing away with court warrants. In the Constitution, even under martial law, warrantless detention can last only up to 3 days before the suspect must be brought to court.
In short, with the Anti-terrorism Act as part of the law of the land, it is as if the Philippines is permanently under a situation worse than martial law.
Under the Human Security Act, a warrantless arrest must be a result of prior surveillance. A surveillance-prompted arrest can happen if the subject is caught in the act, one of the 3 valid grounds for warrantless arrest under the rules on criminal procedure. The anti-terror law removes this requirement. It also repeals the provision under the Human Security Act that awards 500,000 pesos per day of wrongful detention, which, security officials say, prevents the police and the military from making arrests. To declare a person or group as terrorist, the government must seek a prescription from a court. In the Human Security Act, the court may declare a person or a group as a terrorist after a full trial. In the new law, an individual or group can be declared a terrorist within 72 hours, even without a single hearing. This is called a preliminary prescription. A full trial must be completed within 6 months, deciding whether a declaration should be issued, made permanent, or lifted. Apart from prescription, the Anti-terrorism Council, composed of cabinet officials, would also have the power to designate an individual or organization as a terrorist group once it finds probable cause. The ATC may request the Anti-Money Laundering Council to issue a freeze order on the designated individuals or an organization's property or funds which may be linked to financing terrorism. If proven, these could be seized by government. Even if the law is tough, Lacson says there are safeguards under the proposed measure. A provision under Section 4 states that terrorist acts shall not include the exercise of civil and political rights such as protests.
There is a killer provision which says which are not intended to cause death or serious physical harm to a person, to endanger a person's life, or to create a serious risk to public safety.
Look closely at how the law is worded. It would lead one to initially believe that dissent is not terrorism. But because of other parts of the provision, the entire thing actually says that dissent is terrorism if there is an intent to cause harm or risk.
The general rule is dissent is an act of terrorism.
And under the law, the burden of proof shifts from the prosecution to the suspect to prove that his dissent has no terroristic intent.
To incite a person is personal. So like if you say something, even if it is very neutral, if I am a law enforcer and I say, and I can testify that I am incited to rebel because of your statement, then I can use that as evidence against you and detain you to jail for 24 days.
Under the law, there are bailable offenses like threatening, proposing, and inciting to commit terrorism and membership in a terrorist organization. But under Section 34, a person charged with these bailable offenses can be placed on house arrest, where all means of communication would be cut off.
That is bailable, but the accused can be placed in house arrest, negating his constitutional right to bail.
The most prominent law groups in the country, the top law schools, and the Integrated Bar of the Philippines all say there are unconstitutional provisions in the new law, most especially the power of the Anti-Terror Council to order arrests and detention, when these are powers reserved only for the courts under the Constitution. Remember this, under the new law, a person who expresses dissent can be arrested and detained for 24 days. If law enforcers say the dissenter intended to harm a person or pose a risk to public safety.
A lot of things can happen in 24 days. 24 days, there can be torture here.
If the prosecutor sides with law enforcers and charges a dissenter with the non-bailable crimes of terrorism, conspiring to commit terrorism, and planning to commit terrorism, he or she will remain in detention for the entire duration of trial.
You can just imagine a person rotting in jail for no offense having been committed, but only on a mere act of suspicion. So it's very dangerous.
If the one charged is acquitted, there's no automatic penalty for law enforcers. He or she would have to file the counter charges and endure another trial. There's also the question of whether prosecutors can be independent of the Justice Secretary who sits in the Anti-Terror Council.
You can always appeal to the Secretary of Justice, who is a member of the Anti-terrorism Council, and he can always reverse me.
Everyone agrees that terrorists must be stopped in their tracks. But does the government need these broad powers to do so? Does this government deserve such broad powers? For that matter, does any government deserve such broad powers? And do we trust the Philippine police and military to use these powers responsibly?